Welcome to Bar 10 Explanations, the contract. Today we will review the general picture. A contract is an agreement between private parties creating mutual obligations enforceable by law. The basic elements required for the agreement to be a legally enforceable contract are mutual assent, which is expressed by a valid offer and acceptance, adequate consideration, capacity, and legality. Contracts are promises that the law will enforce. The promise is the manifestation of intent to act or refrain from acting in a specified way. A promise or performance must offer some legal detriment, such as something of value or some form of freedom. If a promise is breached, the law provides remedies to the harmed party, often in the form of monetary damages, or in limited circumstances, in the form of specific performance of the promise made. A promise can be unenforceable. A conditional and illusory promise is a promise that is unenforceable due to indefiniteness or lack of mutuality, where only one side is bound to perform. An example of this would be an agreement between a seller and buyer which states that the seller agrees to sell all of the ice cream he wants to the buyer. One party cannot convert what both parties knew to be a joke into a serious transaction simply by claiming it to be so. There must be a meeting of the minds. A meeting of the minds is an essential element in the validation of a legally binding contract. Meeting of the minds refers to the comprehension and mutual agreement or mutual assent of both parties to a contract's terms. When a promise is vague and with indefinite terms, courts use several ways to determine intent. In a contract, intent refers to the determination of parties to act or perform in a particular manner. It's a state of mind with which the parties entered into contractual obligations. Since it's difficult to prove the intent directly, it's often presumed from facts and circumstances of the contract. Courts look at the language of the contract, the dictionary definition of terms, any prior negotiations between the parties, trade usage, standards incorporated by reference, and the conduct of the parties. Contracts arise when a duty comes into existence, because of a promise made by one of the parties. To be legally binding as a contract, a promise must be exchanged for adequate consideration. To constitute consideration, a performance or promise must be bargained for or sought in exchange for another performance or a return promise. Each party has the duty to bargain in good faith. There are two different theories or definitions of consideration: bargain theory of consideration and benefit-detriment theory of consideration. Under the benefit-detriment theory, an adequate consideration exists only when a promise made to the benefit of the promiser or to the detriment of the promisee, which reasonably and fairly induces the promiser to make a promise for something else for the promisee. For example, promises that are purely gifts are not considered enforceable because the personal satisfaction the grantor of the promise may receive from the act of generosity is normally not considered sufficient detriment to constitute adequate consideration. Under bargain for exchange theory of consideration, adequate consideration exists when a promiser makes a promise in return for something else. Here, the essential condition is that the promiser was given something specifically to induce the promise being made. In other words, the bargain for exchange theory is different from the detriment-benefit theory in that the focus in bargain for exchange theory seems to be the party's motive for making the promises and the party's subjective mutual assent, while in detriment-benefit theory, the focus seems to be an objective legal detriment or benefit to the parties. In some instances, detrimental reliance acts in place of consideration. Detrimental reliance occurs when a party is reasonably induced to rely on a promise made by another party. For more information regarding contracts, see our other Bar 10 explanation videos for a quick review. Additionally, you can find most of the principles of the common law of contracts outlined in the Restatement of the Law 2nd, Contracts, published by the American Law Institute. Thank you for watching another Bar 10 explanations. Don't forget to subscribe to our channel. See you next time. And just remember, if you intend to make a promise, make sure it is clear and definite and is followed by some type of consideration.